Welcome, everyone, to the HospitalityLawyer.com seminar series, Labor and Employment Challenges in the Hotel and Restaurant Industries. Today is June 14, 2023. I'd like to remind you that 2 additional programs will be happening later this year: our risk management and loss prevention, focusing on hotel and restaurants, and then our legal challenges in the contract food service management industry will happen in November. Please join us for those. Also, remember, coming up in Washington, D.C., our Hospitality Law Conference, Wednesday, October 18th, the very prestigious Army-Navy Country Club in Arlington, Virginia. We hope to see you there. Kicking us off today, focusing on accommodating employees' disabilities, religious beliefs, gender transitions, and pregnancy-related disabilities, is Andria Ryan. Andria is a partner in the Fisher & Phillips law firm in the Atlanta office. She also co-chairs the Hospitality Industry Practice Group and is deputy, tough word for me, general counsel to the firm. Take it away, Andria.
Thank you, Stephen. Good morning, everyone. Accommodation issues are tough. And the reason I think they're tough is because every good employment lawyer and HR professional you talk to will tell you the way to avoid discrimination claims is to be consistent, right? Treat your employees consistently, and in frontline operations and managers and leaders, they know that, they understand it, that they get the concept. Well, when it comes to accommodations, we're generally treating people differently. So it goes against what we teach every day. But as you all know, we have an obligation as employers to reasonably accommodate in a couple of different areas. We must accommodate an employee's sincerely held religious beliefs. That's not a new law. That's in Title VII of the Civil Rights Act. It's been around for a long time. So we've got to train to this issue. The Americans with Disabilities Act was passed in 1990, and it has an affirmative obligation for us to accommodate employees' disabilities unless there's an undue hardship. There's a law coming into effect in about 13 days that will require you, at the federal level, many states already have this law, to accommodate employees' pregnancy-related disability. And then we'll talk a little bit about gender transitioning employees, which is not as clear in terms of your obligations. But let's look at the next slide and talk, and we'll focus first on religious accommodation. It's interesting when I'm talking to operations, I'm talking to your leaders and managers, we spend a lot of time on religious accommodation because it seems to go against, as I said when we started, it goes against everybody's sort of grain. If I require everyone to work, I mean, on a Saturday or Sunday, or at least 2 Saturdays and Sundays a month during our busy season, why would I let somebody not work on a particular day, for example, because of their religious beliefs? It doesn't feel fair. So again, we've got to train to this. We need to train our leaders and operational leaders. Let's first look at this issue, and that is, we are required to accommodate an employee's sincerely held religious beliefs. I wish I could give you all a list of religions and the various accommodations you might have to consider, but I can't. The courts have long held that we are not going to question, we're not going to require there be a brick and mortar building, a pastor, rabbi, or otherwise. If someone has a religious, spiritual belief, then we as employers are generally required to accept their representation that that's their belief. And I would urge you not to get hung up on the issue of whether the employee has this sincerely held religious belief. Unless you have actual evidence that they don't, which is hard, then let's move on. I generally would recommend to you that we move on to the next issue, which is, can I as an employer reasonably accommodate these religious beliefs? So again, the definition of religion is broad, all aspects of religious observance, practice, and spiritual beliefs. And once we have that presented by an employee, we have an obligation to explore whether we can accommodate that to the extent that it conflicts with an employment requirement, say a schedule, for example, unless there's an undue hardship. Now, undue hardship is a defense to not accommodating an individual. However, remember, if you claim undue hardship, it's the employer's obligation to prove what that undue hardship is. Cultural, social, political beliefs do not qualify. Remember, it needs to be a spiritual belief. So let's talk a little bit more about the next slide. I list some options here about religious accommodations. There could be others. I don't want to, in fact, one of the others that we saw over the pandemic period was an objection to taking the vaccine. It's not on my list, but it could be. Some of it is appearance issues, right? Some people may need to, veil their face, or their religion requires them to wear a dress and doesn't permit women to wear pants. Some will say certain piercings will be a religious or cultural requirement. Prayer time. Someone may say, I have, my religion requires me to pray at certain times of the day. Can you modify my break schedule and my meal periods so that I can pray? And if my breaks don't coincide, will you allow me an additional break so that I can pray at certain times? You may or may not be able to accommodate that. But remember, when you're deciding not to accommodate, this employee will no longer work for you. Or an applicant. If an applicant says they have an accommodation need and you say, we cannot accommodate that because it's an undue hardship, that individual is not coming to work for you. Because, for example, if the employee said, okay, fine, I don't need the accommodation, I'll come to work, they didn't need it in the first place. So operating under the presumption that people are being honest with us, we will continue to move forward with the accommodation process. Let me pause for a moment on the Sabbath observance, because this is probably the most common accommodation request I work with clients on handling. And it's often someone who can't work on the Sabbath, sundown Friday to sundown Saturday, for example. And the example I often give, again, in this industry, 24/7 in many operations, 365, for restaurants, obviously, 7 days a week for the most part, busy schedules and short staffing. We all recognize that, right? So when somebody comes to you, let's say it's an applicant, let's say it's a current employee, the first time they show up on the schedule on a Saturday, or perhaps someone has converted to a religion, they got married and they converted to a particular religion that has this requirement. And they come to you and they say, oh, I'm so sorry, I can't work on the Sabbath, sundown Friday to sundown Saturday. And I often use these two examples. Let's say you have a department with 10 bellmen, and you've got one bellman of the 10 who says, I can't work on Saturdays. And you say, well, that doesn't seem fair. And I need all 10 to be working on Saturdays. I need that rotation. And it'll be a pain in the neck to try to schedule around that. Well, I assure you, pain in the neck on scheduling is not an undue hardship. So set that aside. But I always remind people, listen, you've got an employee here that won't work on his Sabbath or her Sabbath, but will work on every Sunday. They'll work on Sundays no one else wants to work. They'll work Easter Sunday and Mother's Day and Father's Day and all those Sundays that other folks would like to have some free time. So creative scheduling might work with your 10 bellmen. But on the other hand, let's say you are hiring for an engineer that is, and you're hiring one who's HVAC certified, and you need two, at least a minimum of two on your engineering staff for emergencies. And you've got an applicant who says, I can't work on sundown Friday to sundown Saturday. That is likely an undue hardship, because it would leave you with only one engineer who's HVAC certified. That particular engineer could never get sick on a Saturday, could never go on vacation, can never have an emergency, right? So you can see that that undue hardship might exist in those circumstances. So I don't, again, there's potentially many other kinds of accommodations you might be asked from employees, but the scheduling and the Sabbath observant is probably the most common. So Marilyn, let's take a look at the next slide. Again, I mentioned that religious accommodation tends to get people, heavy discussions when you talk to your folks in operations. More likely than not, though, you are going to get a request for accommodation based upon disability. And the reason I say that is not because there's less religious people. The reason I say that is because the Americans with Disabilities Act defines disability in such a way, in such a broad manner, that it encompasses an awful lot of conditions and individuals. Disability is defined as a physical or mental impairment that interferes with a major life activity. Well, major life activities are pretty much everything. Thinking and walking and talking and seeing and hearing and concentrating. So as you can imagine, the breadth of potential medical conditions that might be considered a disability is very, very broad. In fact, Congress, the last time they amended the Americans with Disabilities Act, purposely broadened the definition of disability to include more people. So on our next slide, you will see some examples, right? So obvious physical impairments, such as someone with missing limbs, back injuries, carpal tunnel syndrome, someone with vision impairments, hearing impairments, someone in a wheelchair. Those are very obvious examples of disabilities. There are certain disabilities that are hidden, right? Cancer and epilepsy and seizure disorders. And so we may learn of those, or blood diseases, bone conditions. We may learn of those things when the employee tells us they need something. We would have otherwise not known they had a disability. And of course, impairments like ADHD, depression, anxiety, Asperger's syndrome, those are disabilities as well. So, you have to be looking for folks that not necessarily appear to be disabled. And many of your employees have disabilities you will never learn about, never need to know. It's when they come to you and they're unable to perform go ahead, Marilyn, to the next slide. They're unable to perform an essential function of the job or some of the functions of the job that you have to consider the accommodation obligation. Remember, the Americans with Disabilities Act requires you to accommodate an employee so that they can do their job. I always try to emphasize that when I'm talking to HR folks and leadership. We're not modifying the job so that we can hire someone or retain someone. We are making an accommodation so that the employee can perform their job. So we may modify a schedule. Let's say, for example, an employee has a medication that they're taking, or their doctor is adjusting their medication for, say, a condition like narcolepsy. And they come to you and say, I've always suffered from narcolepsy. I've used a medication that's not working anymore, and I'm trying a new one. And my doctor says I cannot drive safely in the dark. Can you modify my schedule so that I can safely commute to work and home and under my doctor's orders? So there, maybe not, right? It's a discussion that we're going to have with the department, with the employee, and potentially even the employee's doctor. We certainly have a right as an employer to ask for some information to make this determination. We're not entitled to the employee's medical records, nor do we want them. We simply want some information from the doctor that tells us they have the condition and what the needed accommodations may be. We may have to modify duties, but not essential functions. We never have to remove essential functions. So how do you define essential functions? Look at your job description. At the top of your job description, the list of essential functions, the list of the functions at the top of the job description should be the essential functions. They shouldn't be listed in reverse order or intermingled, right? The top most important functions are your essential functions. So you don't have to remove them. You have to modify things to allow the employee to perform those essential functions. You may have to modify a workstation or a work area at your cost. The law actually contemplates that private employers are going to spend their own money to make it possible for disabled people to work. Some businesses may be very small and the cost may be prohibitive. That may be an undue hardship, but for a larger operation, several $1,000s is often not considered a financial hardship or an undue hardship on a business to do some kind of modifications. Let me mention leave of absence here because I included leave of absence on this list, but as you see on the next slide, you never have to give an indefinite leave of absence as an accommodation. So a reasonable accommodation may be, I've been diagnosed with cancer, I'm not eligible for FMLA, may I have a leave of absence and return to my job? My doctor says I can return in 60 days. That may be a reasonable accommodation. We're giving the employee a leave of absence so they can return and perform the job we hired them for. But you should never provide, and it's never considered reasonable to provide an indefinite leave of absence. So if an employee says, I don't know when I can return, my doctor doesn't know when I can return, that's not a reasonable accommodation. And I urge you to be very cautious about granting those kinds of leaves. What you really want the employee to ask for is a finite period of time for their leave of absence. If they need to shorten it or extend it, they should stay in touch with you and provide you that information. The other thing you do not have to do is permit erratic attendance. So let's say an employee, for example, with migraine headaches may wake up one morning, and as anybody who suffers from migraines may know, unable to predict whether I can turn the lights on, open my eyes, work and function in a useful capacity at work. The employee must still call in properly. They must still call off properly. And we can't, and a reasonable accommodation, maybe the doctor tells us that due to this employee's migraine headache, she may miss 2 to 3 days a month of work. When she starts missing 7 or 8 days a month, we go back to the doctor and say, 2 to 3 days a month was reasonable, but now this employee has a pattern of 7 to 8 days a month. Can you please provide further information? And at least alert the doctor that there may be something that they need to do to correct this erratic attendance. And again, you never have to restructure the job to eliminate essential functions. So it's very vitally important that you look at your job descriptions, if you haven't in a while, to make sure that you have all essential functions listed on that job, including physical and mental functions as well, right? So if you need people to concentrate, work in heat, climb ladders, whatever it may be, let's make sure we're concentrating on more than just lifting requirements, because that's where we seem to concentrate on those as well. Points to remember before I leave disability accommodation. It is the employee's responsibility to notify you that an accommodation is required. We shouldn't have discussions with employees about their medical conditions. We certainly shouldn't initiate discussions about employees' medical issues. So you don't have an obligation as an employer to say, you seem to be having trouble with your back. Is there something we need to do? You hire adults for the most part, and you should count on them to bring forward their request for an accommodation. In fact, I would urge you to put an accommodation policy in your handbook, a reasonable accommodation policy that tells employees what your accommodation obligations are, and provides them with a method to request in writing or otherwise an accommodation. Again, the employee doesn't have to provide extensive information. They don't need to say, I'm requesting an accommodation under the Americans with Disabilities Act. We're supposed to know as employers that if someone with a medical condition is asking for some sort of adjustment to work, that our obligation to engage in the interactive process, as you see, I've put it in quotes here in the third bullet, that's our obligation. You will be asked if a discrimination charge or lawsuit is filed, show us evidence that you engaged in the interactive process with this employee. You are obligated to have a discussion with the employee about the needed accommodation, what the employee thinks would work as an accommodation, what you think may work as an accommodation. You get the final decision. So if your accommodation, the employee seems burdensome, or you think there's an alternative, you get to choose that. But if it doesn't work, you go back into the interactive process to discuss alternatives. And then, of course, a disabled individual is not required to accept a particular accommodation, but that may make them, unqualified for the position, and you may have to separate them. So again, remember, religion, disability, and now let's talk a little bit about, I think, gender transition is pregnancy related disabilities. So we are just around the corner from the effective date of the Pregnant Workers Fairness Act. Many of you may be in states that already have a pregnancy accommodation obligation. This is the federal law. So it basically has filled the gap. The Americans with Disabilities Act that we just talked about said pregnancy is not a disability. It's a short-term, non-chronic condition that ends at a certain period of time. So this law is filling the gap. It requires you to provide reasonable accommodation for employees with medical conditions that are related to pregnancy and childbirth in the same way that we discussed you would accommodate for disabilities under the ADA. Identify the restriction, engage in the interactive process. It definitely has a specific prohibition for placing a qualified employee on a leave of absence, a pregnant employee, when other reasonable accommodation option is available. That some employers would resort to that. I mean, I can't accommodate you or I don't want to accommodate you, and so you can go on a leave of absence. It's meant to allow employees to save, obviously, their leaves of absence, their FMLA, for example, for later in their pregnancy or when the child is born. And of course, like every other employment discrimination law, it has a prohibition against retaliation against employees for seeking or taking reasonable accommodations relating to their pregnancy, childbirth, or a related medical condition. So if you haven't, it's time for a policy. So make sure you update a pregnancy accommodation policy in your handbooks. Make sure you're complying with your state accommodation and leave of absence laws, as well as the federal one. As I mentioned here, 30 states and the District of Columbia have some sort of pregnancy accommodation law. And so this is yet another addition to your employee handbook and your policies. You know, I've been doing this for a long time. I've been doing employment law for a long time, and I spent 20, maybe 25 years. And didn't talk to a single employee about a transitioning employee, an employee who identified as a different gender. And it is a almost daily, if not weekly, discussion with clients that I work with, especially in the hospitality industry. So it's a reality. I ask the people that I talk to, I said, you must set aside whatever your political, personal, societal beliefs are about this issue, because as an employer, this is a sensitive issue, and it's one that is it's just ripe with potential pitfalls. So Congress has not passed a sexual orientation, gender identity, any kind of protections in employments. The courts, administrative agencies many of them have filled in the gaps. So a non-discrimination policy ought to address this. Your non-discrimination and harassment policy should address sexual orientation, gender identity, there's a wide variety of areas. So the Supreme Court issued a case in 2020, issued a decision, the Clayton County case, a series of cases. It's a discrimination case, basically indicating that discrimination on the basis of sexual orientation, gender identity is going to be considered a form of sex discrimination. The EEOC has issued guidance regarding sexual orientation and gender identity discrimination and accommodation as well. As a practical matter, go ahead, Marilyn. As a practical matter, the EEOC's guidance is not law, but it certainly provides guidance to their investigators in cases like this, and should provide guidance to us as employers. You may not discriminate on the basis of sexual orientation or gender identity. You cannot create or tolerate harassment based upon sexual orientation and gender identity, which of course is why I want you to update your policies in this area. You can't use customer preferences to assign work, fire, refuse to hire individuals based upon their sexual orientation or gender identity. You can't discriminate because an individual may not conform to a sex-based stereotype for feminine or masculine ideals or behavior. Require a transgender employee to dress or use a bathroom in accordance with their biological sex, and you can't retaliate. So I want to concentrate for a moment on some practical issues in terms of dealing with transgender employees. First, appearance policies. You must and should permit a transgender employee to dress consistent with their gender identity and to comply with the standards of dress for the appearance for those in similar positions. So if you have an appearance policy that has male and female standards, then you must allow and require the transgender employee to comply with the appearance policies of that particular gender. You would address any inappropriately dressed transgender employee the way you would anyone else. So, for example, you have an employee that's transitioning, that's a transgender employee, male to female, and she is complying with the female dress code policies, but wears a 5 o'clock shadow or doesn't shave consistently. Because the transition is complete, the hormones are complete, I understand it to be a very long process. So you would address that transgender employee as you would anybody in terms of compliance with your dress code policies. I always urge the folks that I work with on this issue to deal openly and respectfully and kindly with employees that are transitioning or identifying as not their biological sex, because I rather see that employee cooperate with us and let us show that we're cooperating with them to try to make their work environment comfortable. Again, setting aside how you may personally feel, it's our obligation to make sure that their coworkers are respectful and kind, and so we need to start that process. The other area that we see other than appearance policies, right, is coworkers and guests. You know, you set the culture, provide training to your employees. You know, we recognize that employees are entitled to their beliefs, but we're going to treat transitioning employees with respect, without bias, with kindness, and be prepared. Prepare your employees to address guest concerns. I always remind you that if you have say a spa, fitness center, locker room area where guests go, a transgender guest is going to first encounter not a manager. They're going to encounter a receptionist type employee likely, right? And so let's train those employees on what we expect them to do and say, and how to address those concerns about the use of our facilities. Marilyn? So my best practices for you. In terms of, we're all learning, right? So let's be patient with our employees and our guests and ourselves, right? So be aware and comply with any applicable state, local non-discrimination laws in terms of transgender employees and gender identity. Don't require medical documentation or proof of transgender status. I don't gather that most folks, it seems overly burdensome. Train our managers on how to handle sensitive discussions, expect them to handle them well, be open-minded, discuss the individual's needs, concerns, be prepared to address coworkers' concerns, respect the employee's privacy, and of course, where possible, accommodate our employees who are transitioning or identifying as something other than their biological sex. I think I'm on time, Stephen, and I think I'm on time.
I think you are. Wow, what a great way to kick us off. Thank you, Andrea. Andrea, I have just a quick question for you. Is it, given what's going on in the transgender space, given that it really is challenging for everybody, right? And I think your approach to let's give everybody some grace is very appropriate. But here's my question. Of course, we're having laws passed in certain states, right, around restroom use, et cetera, and that. But my question is this: is it a better practice to have unisex restrooms, at least in the hotel public space? I'm not talking about locker rooms at country clubs or spas just yet, but let's just take the basic public restrooms. Does that help us get down the path a little bit of at least avoiding that issue?
Yeah, I think it does, Stephen. I think it's a good question and it's good advice. To the extent that you can, have all or some gender neutral restrooms, it's a tremendously helpful way to deal with not only the employee who is transitioning, because they're permitted, as you see from the EEOC guidance, to use the restroom of their choice, but for the other employees. So if I'm uncomfortable and I'm a coworker and I just feel like it's a privacy issue, then you have an alternative for me as well.
Okay, and be the same thing in the public spaces, right? Be kind of the same concept.
Correct. Although right. It's difficult, right? So spa locker rooms and things like that are not necessarily easily modified.
No, when we get to those, that's a little different. We still don't, I don't anywhere have a handle on that. If you ever do, please let me know.
I sure will.
Ladies and gentlemen, let's say not only thank you to Andrea Ryan with Fisher Phillips, but also happy birthday.
Thank you. Thank you. Big day.
Safe travels. Thank you for joining us.